Lovely. We will get going. As I say, my name is Hannah. I'm Hannah Haywood and I work at Barney Law. We have been keeping quite an eye on what's potentially about to be coming our way in terms of changes. I think it's certainly going to be an exciting time to be working in employment law and HR. There's going to be lots and lots of changes. And this is just our general commentary, I suppose, our general overview of what we might be expecting. Obviously, there's quite a reputation, I think, sometimes for a bit of a U-turn, some things that might not get all the way through. So we can discuss these today and hopefully you'll have a clearer idea of what might be coming towards the end of this year. Just a little bit about us. We are an SRA regulated law firm and we specialise exclusively in employment law and HR. So this is our bread and butter. This is what we do from the very beginning of that employee journey, all the way through to the end and even beyond, in terms of our litigation as well that we can assist with. That's just a little bit more about us if anybody's interested. And just to say, if you do have any questions throughout this webinar, please put them in the chat box and we'll answer them at the end. So I have allowed for a little bit additional time today, just to make sure that if there's any questions, we've got some time at the end to go through them all. I do appreciate there may be questions we all have that we don't necessarily have the answers to yet. And I will do my very, very best to answer them for you. But obviously, at the moment, we're working on things that aren't necessarily in place just yet. So there may be nuances around there that we just don't know about. But if you have any questions at all, pop them in there and we will go through them all when we can. Lovely. So I think this has been the headline really throughout the entire election campaign of the Labour manifesto. I think we were not necessarily shocked that we saw such a Labour majority. I think, we're not here to kind of discuss the stats around the election. We generally just want to look at, right, what is going to happen now? The law that we might be expecting to come in and abide by and pay attention to. And as I say, the headline was a new deal for working people. So I think the main point of that really is more rights for workers and employees. So it's going to be, and what we have seen is that it's going to be quite employee focused on the working person. And generally the point of this, as the Labour Party have tried to encourage, is that it's encouraging participation back in the workplace. If there is unemployment rates, they are trying to encourage people to get back into work. Now, whether that's because they've had a family and they don't feel that there are family-friendly rights there to protect them, whether they are part of a minority group, whether they have a disability or ill health, a lot of the changes that they have suggested that they would like to make are in line with those groups of people. Similarly to those lower paying roles, such as national minimum wage level jobs, we're likely to see increases in things like that, sick pay, benefits, etc. to employees. So we will cover them in stages, but generally speaking, these are the types of things that we're seeing come through. Now, I think there's not bundles and bundles of information in their manifesto. It is, as I say, they're kind of headline points of this is what we want to do. And I think we all know, there's a very stringent judicial system, which means they're not necessarily going to get absolutely everything that they want passed in the way that they want it to be. And hopefully, the point is that there will be a balance between those employee rights and support for businesses, especially small and medium-sized businesses, in putting these changes into place. They have, throughout their manifesto, pointed out elements of support for businesses, but I think generally speaking, it is very worker and employee focused. So those are the main things that we're going to focus on today, the things that we expect businesses will have to input or at least pay some form of attention to in the coming weeks and months. So the big one for me, I thought we'd start relatively big, is unfair dismissal and other day one rights. So the current position is that in most circumstances, not all, but in most circumstances, an employee needs at least 2 years continuous service before they are able to pursue a claim of unfair dismissal. Now, that doesn't necessarily mean that employers do not have obligations to follow correct processes with less than 2 years. It's just the risks of a claim are generally much lower because there is that limitation, that time limitation. Somebody needs to have that continuous service of 2 years before they are eligible to pursue that claim. Now, Labour have proposed that there would be an introduction of an unfair dismissal claim being a day one right. So similarly to the right to pursue a claim of discrimination, you have the right to pursue that claim from the very first day of your employment. That has been kind of nuanced and subjected to probationary periods. So I think we are expecting to see something along the lines of, outside of that probationary period, you would be able to pursue an unfair dismissal claim, but probably a lot more focus on that probationary period as more of a trial for both sides to see how things work out. At the moment, probationary periods make a difference in relation to notice, generally a contractual entitlement to notice, and is generally there to manage the employee's expectations in terms of we're going to have a review after 3 months or after 6 months. But legally, at the moment, a probationary period doesn't change that much, whether you're in or out of the probationary period. If you've got less than 2 years service, there's the limitation in your ability to pursue that claim. So this change could see that probationary period carry a lot more weight and provide a lot more in terms of rights for that employee in order for them to pursue that claim. I think it is certainly something to note that employers need to be aware of what their probationary periods are, whether they need amending within their current contracts for new members of staff. But we are yet to see whether, there would be any allowance for what a reasonable length of time is for a probationary period, because, for all intents and purposes, you could potentially put a 2-year probationary period in there, meaning that outside of that 2 years, then you've got the right to pursue the claim. I can't see a 2-year probationary period being considered reasonable. However, we haven't got those limitations yet. So I think generally it's very common to have a 3-month or a 6-month probationary period, dependent upon sometimes the seniority or the industry that you're in. And so I think it's likely that those will remain to be considered reasonable. And potentially within that probationary period, employees may not have the same rights as they would once they've passed that probationary period. So those probationary review meetings as well may need a lot more attention and a lot more focus than they currently do. There are other additional day one rights suggested, so potentially to include the right to sick pay and parental leave. So obviously at the moment, statutory sick pay becomes payable on the 4th day of absence, so you get the first 3 days unpaid. It has been suggested that that would be paid from the very first day of sickness absence. Now, I think it's quite common for contractual sick pay to cover that period anyway. This is obviously just for the statutory position, and similarly for different types of parental leave. And again, it's generally a suggestion within the manifesto. There's been little detail as to what that would look like moving forward, but I think this could see a surge of additional claims. At the moment, as I say, the first question you ask essentially is, as an employment lawyer, when somebody comes to you and says, I'm looking to pursue a claim of unfair dismissal, it's what length of service do you have? How long have you been employed there? That's the very first question, because it's the first boundary to get over. Removing that boundary, I think, is going to allow for a lot more claims to be pursued in the employment tribunal. So it's certainly something that employers need to be paying close attention to. 0 hours contracts. Now, I think it's been quite a headline that Labour want to ban all 0 hours contracts. As you can see from the slide, what they've actually proposed in their current manifesto is not an outright ban, but rather a ban on exploitative 0 hours contracts. So the current position is similar, to be honest with you, from case law that we've seen. 0 hours contracts need to reflect the reality of the situation. So we will often advise our clients, if you have somebody that is consistently working 20 hours a week, they always work a Friday, Saturday, and a Sunday, and you want to put them on a 0 hours contract because you don't actually want to allow them to have that many hours anymore. The reality of the situation is if they've been working in that pattern and for that many hours every week consistently, they're probably not a true 0 hours employee, and therefore you're going to have more obligations to provide those hours for them. The proposed change is essentially to ban employers attempting to do that and ensure all jobs provide a baseline level of security and predictability. They have referenced a 12-week reference period. So if you were to have somebody, as I say, consistently for those 12 weeks working 35 hours a week, consistently 5 days in a full-time role, they would have the right to request a contract that reflects that, rather than being on a 0 hours contract. If you have genuine 0 hours workers, you may have students, for example, who come back every odd weekend and will cover a shift for you, or you have people who might work, just for 3 weeks over Christmas because it's your really, really busy period, and then they don't work at all for you in January. They might do a random shift in February. That's a more true 0 hours relationship, and it doesn't look like they would be banned in any way. It has been acknowledged that there is value to that for certain people. I know when I was a student, I very much saw the value of a 0 hours contract because I didn't want to necessarily be held to set hours. And that can work both ways. And that is what a 0 hours contract is meant to be, that there's no obligation to provide those hours, and there's also no obligation to accept those hours as a worker or an employee. And therefore, this potential change is for those individuals who do want to be working set hours, who have been working consistently for you, and who require that level of security. Okay. The Race Equality Act. Now, this is a relatively small point within the manifesto when we were reading through. There's, as I say, not bags of detail. Currently, we have the Equality Act 2010, which does outline race as a protected characteristic within that piece of legislation. So if anybody is to be directly discriminated against on the basis of their race, they would have the right to pursue that claim, and that is protected in law. Now, this proposed change would enact an additional piece of legislation. It's not to remove or replace the Equality Act. It's not to get rid of it. It's an additional piece of legislation that would allow for race equal pay claims and also strengthen dual discrimination claims. So currently, somebody could pursue a claim for equal pay on the basis of their sex. So generally speaking, if there is a man and a woman doing the same or similar work and the man is being paid more than the woman can pursue a claim of equal pay. This could potentially allow for somebody to make a similar type of claim, but on the basis of their race. If they can evidence that they are doing the same or similar work, and the only difference between those two comparators is their race, then it's looking likely that this piece of legislation specifically will allow them to pursue that type of claim, in addition to the protections that they already have within the Equality Act. Okay, so it's potentially something that you may have been able to shoehorn in under the current legislation, but this is going to allow for an additional claim, but also obviously strengthen those additional other claims that you were already being able to pursue under the Equality Act 2010. Reporting requirements. So this is generally looking at those larger employers, so employers with more than 250 employees. It has been suggested that they will have to have in place a menopause action plan. So this has come off the back, I believe, of a select committee that were reviewing whether menopause should be considered a protected characteristic under the Equality Act. Now, it wasn't deemed that that's necessary at this point. However, it's clearly something that the government are paying attention to and taking note that this is an issue within the workplace. And I think it's clear that there is a percentage of the workforce that are dropping off at a certain point in their life, and that is really lining up with women who are then hitting the menopause. And And I think it's something that we need to be paying attention to. And again, coming back to Labour's point of keeping people in work and allowing people to remain employed and feel supported in the workplace, this is in line with that in allowing those people to remain employed should their employer provide that additional support. It's also suggested that employers with more than 250 employees will have to produce ethnicity pay gap reports and disability pay gap reports. So whilst there's already an obligation to produce gender pay gap reports on larger employees, this would be an additional obligation for as I say, ethnicity pay gaps and disability pay gaps. So that would be documenting all the employees you have within your business and essentially outlining whether there is a disparity in pay or not. They've also gone one step further with the gender pay gap, and they will require larger employers to publish action plans on how they intend to close their gender pay gaps. So what does that look like in your business, and what are you doing about it? So not just reporting it and having to declare it publicly, but also what are you doing as a business to combat that and to ensure that that gender pay gap is disappearing. Again, the detail around what's going to be required in those reports, where they're going to have to be published, within what time frame, we don't have yet. But at the point, obviously, these things are coming through as legislation, we will, of course, keep you all updated. It's clearly something that I enjoy in my spare time, keeping an eye on what they're passing through. So I will be sure to let you all know. For smaller employers, I think it's likely this will trickle down to smaller businesses, whereby you're not going to have the same obligations. However, they have suggested they will be publishing guidance to support smaller businesses in keeping these things at bay. And if you are growing as a business, in supporting you in getting over that 250 employee mark, to then having to produce these reports. They've also said they will be publishing guidance in relation to menopause within the workplace and outlining things for employers to consider, such as uniform, temperature, and flexible working. So, is this something that you need as a business to consider? I think it's very common now. We're seeing a lot more of our clients inputting menopause policies or practices in the workplace or training for their senior leadership teams, and really paying attention to menopause and the issues that it's causing within the workplace for staff and for businesses. And so this is, I think, just a reflection of that from the government now to say, we've seen it, we've acknowledged it, and we're going to do something about it. And this is the guidance that we're going to publish to assist you with that. Family-friendly rights. As we said at the beginning, it's kind of really all centered around getting people back into the workplace. Have you left the workplace, or do you not feel supported in the workplace because you've got a new family or you've just started having a family? And what can the government do essentially to get people in work and remaining in work, and as I say, feeling supported in work? So we've recently seen probably the biggest changes to employment law that we've seen for perhaps a decade, just in April this year with the Conservative government and the protections that they've inputted for employees who are pregnant or on maternity leave. And that was extending their protections for redundancy. So this was a specific redundancy protection that is now in law, and this is in place from April this year, whereby if somebody has gone on maternity leave, or from the date, that they've given birth, they have an 18-month protection, meaning that if they've had a year off, it might be the 6 months from them returning to the workplace, that should they be put at risk of redundancy, they have the right to be given any suitable alternative role, where it exists. So should a not suitable alternative role exist, and there are potentially two people that could go into that role, the person who is on maternity or just returned from maternity leave will have to be put into that role. Now, Labour look like they're going even further than that in essentially producing an outright ban on dismissing pregnant women for any reason, not just redundancy. So that includes capability, potentially misconduct, for any reason during their pregnancy or up to 6 months after a return to work, so a similar time frame, except in exceptional circumstances. Now, again, There's no detail on what these exceptional circumstances would be. However, I think if we take a common sense approach to this, they've been stealing funds from the business. That's likely to be an exceptional circumstance. Potentially, they've lost their right to work in the country. Is it going to be illegal for them to continue working for the business? That's likely to be an exceptional circumstance. I think if you're ever, even now, before any of these changes happen, even now, if you're considering dismissing a pregnant employee, I think you need to take advice, because it is already a relatively high risk situation, no matter the circumstances. And so I would urge you to seek advice in relation to that, especially redundancy with how the current law stands. But if this change does come into fruition, then in any circumstances. And I think it's likely we will see case law produced when people are testing these things to outline what those exceptional circumstances are. Ideally, we get some examples. I don't think we will. But I think, yeah, as I say, taking a common sense approach, if it can be deemed exceptional, what is that reason? So it's unlikely that I think you'd be able to dismiss somebody, sorry, when you haven't followed a full and fair procedure. That's going to go without saying. So as I say, we will keep an eye on what these exceptional circumstances may or may not be, but that's certainly going to potentially allow for many more claims to be pursued on behalf of pregnant people or people who have just given birth and returned to work. They would also, as I say, ensure parental leave is a day one right with a view to supporting working families. So again, those additional parental leave rights, there's a number of different allowances, and they're all going to be from day one, potentially. How that extends to pay as well as the leave is yet to be seen. So there is a difference between your right to leave and your right to pay. At the moment, they've just stated their right to leave, but as I say, it's something that we're going to keep a close eye on as to how that extends to any statutory payment that person would therefore be entitled to. They've also stated that they would go even further in support of flexible working and make it the default position from day one for all workers, except where it's not reasonably feasible. So again, we saw a huge change in flexible working in April this year from the Conservative government, which meant that the previous position prior to April was that somebody needed to be employed for 26 weeks consecutively before they were able to make a flexible working request, and they could only make one a year. That changed in April, so that from the very first day of employment, you can make a flexible working request and you can make up to 2 a year. They also set additional guidance and boundaries for employers to have to justify why they can't allow the flexible working request, and to ensure that there's adequate consultation between employers and employees. So this would go even further in, rather than it being just this day one right to request it, that it would be the default position, except where it's not reasonably feasible. So I think reasonably feasible, if you work in a factory and you have to be in the factory to do the work, you can't request to work from home, those types of things. However, flexible working can take many, many forms. This isn't just a request for somebody to come in late because they've got, other allowances. This is a permanent or temporary fixed term change to their terms and conditions. So it may be, I want to change my hours from 9 to 5 to 7 to 3, or from 10 to 6, or I want to shorten my hours, or I want to compress my days, or I want to work from home 2 days a week, or I want to just work afternoons, or whatever that flexible working request is. It can take many, many forms. Potentially could now be seen to be the default, except where it's not reasonably feasible. Now, my only reservation here is if you are advertising for a role on full-time hours, 5 days a week, for example, and somebody accepts that role on full-time hours, 5 days a week, and then the third day of their employment goes, actually, I want to work 3 days a week, I'll compress all my hours, but I won't be here on Thursday and Friday, and they have the default to do that, I'm not sure where that sits at the moment, because you've clearly accepted a role on certain terms and conditions. And is that just a change of terms or is it flexible working? I think we're going to have to see further justification as to why there's a flexible working request, how it will affect the business, why it's necessary now. Has there been a change in circumstances? As I say, I think we're going to see a lot more in relation to this. We've already seen quite a stretch, as I say, from the previous government. So how much further this can go, we will certainly keep an eye on. They've also stated that they will review carers leave and bereavement leave. And again, how far that extends, we don't know. Carers leave is a brand new piece of legislation, again, just brought in April by the previous government to allow employees and workers a period of leave to care for somebody who ought reasonably to rely on them for care. Again, that's quite a broad definition. So it's not just children, it's not just parents, it's not just your immediate family. It may be that a neighbour relies on you for care and you therefore have the right to leave work to go and care for that person. How employers handle that, again, there are additional nuances around that. So it's not an outright obligation that you have to go, right, okay, I'll see you next week then. You can postpone that leave request. You can't necessarily reject it, but you can postpone it and say, we can't do today, we can do on Thursday, and push that leave back. And so I think if anybody comes to you and requests leave, again, different to pay obligations, it's just the right to leave, you do need to take advice because it's a very new piece of legislation. There's not been many test cases of it yet. And I think it's important that you get the right advice and know what you need to do or what you can and are allowed to do before you revert back to that employee making that request. Okay. We did an employment law update only a couple of weeks ago of the changes that happened in April and covered all these things. And now I think they potentially could be set to change again. Oh, I can see a hand up. Is somebody wanting to put their mic on or pop a question in the box, or was that just an accidental hand? Oh, I think I might have to give you the permission to speak. I do apologise. Was that an accidental hand? Sorry. If you do have any questions, just pop them in the box. And as I say, my colleague will be more than happy to assist you. It might have been an accidental one. So the right to switch off. This is something that we've seen in other countries, actually. I think Brazil have gone very far with it, and it could potentially be verging into a criminal offence. But essentially, since the pandemic and since the flexible working changes that we've seen in many, many different industries, people are now working from home, which, certainly has its benefits. However, I think it's quite common now that them lines are being merged. If you're working from home, are you working later? Are you working at your kitchen table? Are you just checking your emails? Are you on holiday, just checking that email, just responding to that email? And has your employer or have you as an employer essentially become used to that and therefore feel that that is something that you're now expecting of your staff? Do you have the right to expect that of your staff? I think, as I say, these lines are becoming more and more blurred, and therefore they've acknowledged that, and the Labour government have now stated that they would introduce a right to switch off. So it's not an outright day one right, as the other rights that we've discussed could potentially be, but rather a right to discuss switching off. So, is it a case of you going to your employer and saying, right, I'm going to go on holiday for 2 weeks and I do want to, completely switch off. I don't want to be contacted. I've got these other means. I've got, a really good team that you can rely on. If you've got any questions, you can speak to them, but I'm going to be, uncontactable. And not feel that you are going to be punished as a result of raising that to your employer. So they have suggested a similar model to what we can see in Ireland and Belgium. So again, other countries are doing it and they're kind of taking their lead with that. But it's just to give workers the opportunity to have a constructive conversation with employers and not feel that they're going to be penalised as a result. But also acknowledging that there are certainly certain means whereby it's necessary. It might be an absolute emergency and only you can deal with that, especially in smaller businesses, and therefore it's not going to be an exclusive ban that your employer cannot make any contact. And also it might be something that you choose to do. You might feel better being able to keep in contact with work. And I think they've acknowledged that there is value in that ability to do that, and therefore it's not going to be an exclusive ban, but rather a conversation between parties as to what works for you and what is going to be suitable for you and the business. Fire and rehire. I think this has been a headline that has been discussed for years, as to what this actually means and whether it's fair and whether people like it, whether people don't. Generally, it's the practice of an employer dismissing an employee and then engaging them on reduced terms and conditions, usually. So we want you to change these terms and conditions. The employee says, no, I won't consent to that change. And they say, right, okay, well, we're going to get rid of you. And then if you still want to continue working here, you're going to be working on these new terms. Again, with less than 2 years service, very little recourse because no right to pursue an unfair dismissal claim. Should that unfair dismissal become a day one right, subject to probationary periods, then the ability to fire and rehire in not only safe terms, is going to be reduced completely. The Labour government have now suggested they will replace the statutory code that is in place in relation to dismissals and strengthen the code of practice around this practice in any event. Again, very little detail on how they will be doing this or what it will include in terms of within the code of practice. It's quite common that we see the law change and then the statutory code or the code of practice come in afterwards. So there might be a little bit of a gap. But generally, even now, before any changes commence, this is generally not a very safe practice. And again, if you are looking to vary the terms and conditions of any of your staff, I would highly recommend that you seek advice before doing so. If any of them are contracted with you, then to vary any terms of a contract, both parties generally need to consent to that change. That's the safest way to go about varying terms. As I say, in certain circumstances, fire and rehire is a possibility. But it also comes with quite a risk. So in order to do that safely, I would recommend you get specific advice. Collective consultation. So currently, if any organisation is looking to make redundancies and they are looking to make 20 or more people redundant in any 3-month process, then they will need to collectively consult. So that generally means electing representatives of employees, consulting with the representatives, and then consulting with the individuals. And there are also time limitations. You have to consult for a set period of time. There's generally more boxes to tick in terms of a collective consultation. This potential change could be introduced with the aim of triggering collective consultation more easily. So at the moment, a number of employees being made redundant is taken into consideration in one workplace. So if you have one hotel in Sheffield and you have another hotel in Leeds, but dependent upon the business setup, it could be considered that one hotel in Sheffield is considered one workplace, and that one hotel in Leeds is considered one workplace, and that one hotel in Birmingham is considered one workplace. They're looking to make a change whereby if you're making redundancies across the whole business, that they will all be considered as one workplace. So obviously, if you're making 10 people from that business or that workplace redundant, 5 people from that workplace redundant, and then 7 people from that workplace redundant, collectively that's going to amount to 20 or more, triggering that collective consultation, rather than the current process, which is that's an individual workplace, that's an individual workplace, that's an individual workplace, and you don't need to collectively consult. So could have huge implications for larger businesses that currently work in different sites or locations, and avoids that additional requirement. It could create essentially a much lengthier process in terms of your consultation for redundancy, and also make it so that you then will have to notify the government if you are making redundancies, because again, it's just a tick box that is triggered once you go over that number. So if you are making redundancies across a number of different workplaces and you're unsure as to where you fall in relation to collective consultation or not, again, you may need to seek advice in that regard. I think it's going to it's going to have quite an impact, that one, if and when it does come through. Employment status. So this one may not have so much of a direct impact, but I think in my job, for example, it certainly will. You may have different contracts for different people within your organisation, and currently the UK has a three-tiered system. So they have either employees, they have people who are self-employed, or they have workers, which is a general middle ground. And if anybody is as interested in this as I am, you may have paid attention in recent years to the Supreme Court case of Uber that went through. And there's been set precedent, a number of different cases that have set a number of different precedents in relation to employment status. And it's generally quite a complex area, identifying who's an employee, who's a worker. Are they, you can have a 0 hours worker and a 0 hours employee. And what's the difference and what does it mean? And what are my obligations as an employer? What are the different things I have to know and have to do? So the government are proposing that they would move towards a single status of worker and transition to a two-part framework. So you'd either be a worker or you'd be self-employed. I can't see that that's going to, at the moment, workers have less rights than employees. I think it's likely that employees and workers are going to be combined and all the rights of an employee are going to become all the rights of a worker. Can't see them removing rights, just because of the theme we've got going on with these changes. But it's generally with the view to make things clearer so that people know where they sit. Workers or employees, whatever the name they'll kind of come up with, they will know what they are and what their rights are, and employers will know that what legal obligations they have to comply with, and who their staff are under what circumstances. So I think a lot of these interlink with each other. For example, banning those exploitative 0 hours contracts is going to reduce a lot of am I a worker, am I an employee, what are my rights type of claims, and it's going to make things a lot simpler for, right, you're an employee or a worker and you're self-employed. They're your rights and they're your rights, and everybody knows where they sit. This would be quite a change, though, and I think would see essentially an overhaul of people's contracts and working systems. So I can't see this happening immediately, but it's certainly something that we're going to need to keep an eye on because it will impact businesses across the board. So yes, certainly something to bear in mind. And as I say, it may be that we need to be reviewing contracts now to be seeing, right, what are our obligations to you? Are you a casual worker? Are you an employee? Where does that sit? Is everybody clear on what their obligations are with the different systems that we have? And how is that likely to change? Industrial action. So this is quite a broad one. I didn't want to go into loads and loads of detail because I didn't want to scare you all. But essentially, it's not news that the Labour Party has good relationships with trade unions. I think that's going to look to become stronger than it has been in recent years. And we've seen a number of different points within the manifesto in relation to industrial action and strengthening trade union relationships essentially within the workplace. So they have suggested a reversal of the changes made under the Trade Union Act 2016, which is likely to reduce the notice currently required to ballot for industrial action. The action to make it easier for unions to gain recognition in workplaces, a requirement for the Section 1 statement issued to all new starters to inform staff of their rights to join a trade union. So at the moment, the obligation in any Section 1 statement issued to any new member of staff is that you have to outline whether there is a collective agreement in place that affects their employment, but that's it. You don't have to highlight anything else. So this would again go further than that to highlight that they have the right to join a trade union. Whether that would indicate what trade union, they should really have the choice. But what kind of detail around that, we don't know. But generally, as I say, I think this is going to see probably a resurgence of trade union reps in many more workplaces than they currently are, because it also allows potentially for a further right of trade unions to access workplaces for recruitment. Now, whether they're just going to be able to, open the doors of any office and go walking through with their leaflets and placards, I don't know. I can't see that that's going to be the case. But, at the moment, everybody has the right to be a member of a trade union, and they cannot suffer a detriment as a result of being a member of that trade union. So I don't know how much further it could go, because you've got the choice. No one's going to force anybody to become a member of a union, but I think it's just going to be a lot clearer potentially for those new starters in a workplace, or for the more junior members of staff that may not be aware of trade unions and what they do. They're probably going to be a lot louder in that space now. And additional changes. So this isn't necessarily a change that's going to, be something you have to change in your contracts, or an additional change per industry, but these are just some general overall points within the manifesto that I think were important to note. So the removal of age brackets for national minimum wage. You should all be aware that obviously national minimum wage increased from April this year, and there was a removal of the 23 and over bracket. So it was previously 21 and over, and then 23 and over. They removed that, so now 21 and over is the same level of national minimum wage, generally to reflect that somebody who's 21, 22 or 23 may be doing the same or similar work with the same or similar financial obligations on them. Labour have proposed they may remove that age bracket completely. Now, whether that would go as far as to remove any age brackets going down to kind of apprentice level or not, I don't know. But generally, it's looking like they want to enact a set minimum wage across the board, irregardless of age, if they're doing the same job. Like I say, I think certainly one to keep an eye on, dependent upon the apprentice levels, and also kind of 16, 17-year-olds. Is it just going to be from 18 up? We don't know, but certainly a key point within their manifesto. They've also stated they want to enact a single enforcement body for worker rights. How much more than ACAS that is, again, I don't know, but certainly one to keep an eye on. Collective grievances being issued via ACAS. I think that's really interesting, because at the moment, individuals obviously can raise grievances individually to their employer internally. They don't have to have any external involvement from solicitors, HR advisors, ACAS, etc. So this could potentially mimic, I suppose, what a trade union could enforce in terms of collecting every individual grievance together to issue collective grievances via ACAS. Whether that would, create a kind of third ring of what ACAS can do or not, I don't know. Whether it would be part of their advice process or their early conciliation process is yet to be seen. But I think it's going to allow for additional forms of mediation between employees and employers, and employees who feel aggrieved. They're going to have a different form of recourse should they choose to use it. Fair tips allocation. Now, this is in the Labour manifesto, but it's also set to come into law anyway in October this year. It was originally set for July, and then I think Rishi had bigger plans for July, and we saw a general election instead. So they pushed it back to October. So there is additional obligations on employers who have tips. So I think this is going to be huge in the hospitality industry. There's just more obligations on you recording your tips, how you distribute your tips, who's in charge of that, and having the right as a worker to request further information in relation to that. So again, if you're unsure, get in touch. We've done lots of different things about tips, and we're probably going to be releasing a lot more information about that as it comes closer to October. So keep an eye. But I think because it's in the Labour manifesto, I don't think it's going to be one that they're going to scrap just because they've, there's now been a change of government. So that looks like it's coming into force, and something that we need to be aware of, as I say, especially in those industries whereby tips are a lot more common. And the ban of unpaid internships. So kind of does what it says on the tin, really. Any unpaid internship could potentially be banned whether there would be a statutory payment that would have to be made in replace of that, whether it would be national minimum wage, apprenticeship wage, we don't know. But generally, Labour aren't necessarily a fan of free labour. So it's looking like they would be banned. Again, whether it would be considered work experience, whether there'd be any kind of additional requirements, whether it's what kind of constitutes an internship and what doesn't, I don't know. But something that I think we're going to see more information on, because I think that kind of doesn't surprise me that that's in there as part of their manifesto pledge. And time limits. So I think something that's going to have a huge impact, as I say, in my job, in my line of work, and just for employers generally, what they need to know. Currently, most claims in the Employment Tribunal must be issued within 3 months minus 1 day from the date of the unlawful act. That does, there are certain claims, equal pay, for example, that have up to 6 months to issue that claim. Labour have proposed that they would extend this deadline from 3 months to 6 months, so it would bring them all in line. So this doubles the length of time that people have to issue their claims in the Employment Tribunal, which common sense would suggest then could potentially mean more claims within the Employment Tribunal, because people have more time to pursue them. They have stated that this is specifically there to help people who are pursuing certain types of pregnancy or maternity discrimination, because obviously they've had, they've been relatively busy, probably giving birth or raising a small child, to then allow their extended time to pursue that claim after the fact. However, it looks like this is going to be an extension across the board for all claims. So again, it may be that somebody could potentially pursue unfair dismissal within the first 6 months of their employment, and then have 6 months to issue the claim. So it's allowing claims kind of at both ends. You're going to have more rights to pursue them, and then longer to do so. So I think generally overall, we could potentially be seeing more claims in the Employment Tribunal. However, in reading the manifesto, they have identified that there are growing delays in the tribunal. From speaking from experience, there are, and this has been, it's had quite an impact. You could be looking at anywhere between 12 to 18 months from issuing a claim to getting in front of a judge. So it's incredibly difficult, and there are things to suggest that that may be because it is free to issue a claim. So people think, oh, I'll just, why not? Why would you not issue? Just take a chance. There was discussions, again, previously with the Conservative government to reintroduce an issue fee. So somebody would have to pay to issue their claim, similarly to how they have to pay to issue a claim in other civil courts. So it wouldn't be on its own in terms of that, of having to pay to issue the claim. They did have fees. I think it was probably 2014 was when they were scrapped. And therefore they wouldn't be looking to introduce fees as large as they had before. They were quite hefty fees to issue the claim. They'd now be smaller fees, but could potentially look to put off those people who may not have such prospects of success in pursuing that claim. Whether that's going to, still be part of this plan in bringing those employment tribunals up to standard, as was the wording in the manifesto, I don't know. As I say, it was a discussion that was being had by the previous government, so whether that's going to continue to happen or not is yet to be seen. But it's not completely left field and out of nowhere. So what does this actually mean for anybody? It's just a lot of me saying if, buts and maybes, which I completely understand. The Labour government, prior to becoming government, did pledge that they, within the first 100 days of government, would be creating this new deal for working people. So I think their employment rights are going to be top of the agenda in terms of lawmaking and changes that they're looking to issue. The first 100 days of government is not a very long time, 3 or 4 months. So before the end of the year, certainly we could be seeing some of these changes come through. this does mean we have to be on top of them. We have to act quickly. Hence why we've put this on today for everybody, so that we have a general understanding of what may or may not be coming. We can prepare for it and just generally understand it a little bit better. However, what is the reality of passing legislation? So, you know, I'm not here for a kind of politics lesson. We go through two houses and then that, you know, got to have royal assent, etc. Labour do have quite a majority. And therefore, I think we're going to see things getting passed through the system a little bit easier than they may have had in other circumstances. However, it's kind of yet to be seen what may be changed, what details may be put in there or not put in there as it passes through the system of lawmaking. And obviously that takes some time. It's not going to be an immediate, right, we've changed the law, you need to do this tomorrow. We're going to have a date of when they've passed it, of when it needs to be enacted, and it's unlikely it will be backdated. So, you know, we have got time to pay attention to these things and get a plan in place. But if anybody is unsure, obviously, you need to seek advice. These changes are likely to be happening, and we will try and keep on top of it and keep everybody informed. So do sign up to our newsletter. That will be where we're really going to be pushing out that information. But I think it's going to be, as I say at the start, you know, really interesting and relatively fast paced in terms of what's actually going to be happening in the weeks and months to come. So, questions. Does anybody have any immediate questions? I understand that was kind of a whistle-stop tour through of everything. So thank you very much for sticking with me on that. I can see two questions here, so I will answer those. Thank you very much. So did Labour say anything about the prevention of sexual harassment due to coming in October? Assume this is not going to be a change and something they would be on board with. Thank you very much. Yes, I do actually have a slide on that just to come to. They are likely to be very on board with that. There's nothing specific about whether they would keep it or not keep it, but I think, as I say, the general theme is that they're going to be keeping that change in the law. So if anybody's unsure what we're talking about, essentially in October this year, there's going to be a new piece of legislation passed, which essentially means that employers will have to take proactive response to preventing sexual harassment in the workplace. So rather than reacting to it and say, you know, waiting for somebody to come to them to raise an issue, they're going to have to be proactive. So they're going to have to ensure they're training their staff. They've got their policies and procedures up to scratch. They're taking what reasonable steps they can to prevent sexual harassment. We are actually running lots of different training sessions on that. If anybody wants to put their workforce or their employees on that to ensure they're complying with that change in legislation, as far as we're aware, that is still coming into force and that change is still happening in October this year. So thank you very much for that question. Second question, in regard to post-dismissal claims, is there a likelihood that all claims pre the date of the change in law could be seen as a result of the potential changes? No, I think if I read that right, I don't think they're going to predate the change in law. I don't think they're going to be able to go backwards because we weren't to know that any change would happen. So anything that's going to be brought in is going to be from a date of when they enact that law, and we're going to be moving forward from there. I can't see that they're going to be able to go backwards. If I've misunderstood that question, Angela, please let me know. But you can drop me an email, I'm sure. I'm excited for the proposed changes for more flexibility in the apprenticeship levy. Not a question, more of a comment. No, certainly. I think there's lots of changes, and I think no matter where you sit on the kind of political spectrum, there's lots of changes coming. So I think there's going to be some that we're really happy with, some that we're not really happy with, some that are just confusing, some that are really going to work. Hopefully, you know, we can strike a balance somewhere. But I think there's generally just going to be a lot more flexibility. And I can't necessarily see, you know, if the aim is to get people in work and to get the economy growing, hopefully that's going to be the way things are moving. So I think it's certainly something, a space to watch and keep an eye on for sure. Oh, I've seen another question. So realistically, do you think a day one right for unfair dismissal will actually come in, reflecting on the statutory disputes regulation for the previous Labour government? I can't promise you that law that the government pass isn't going to cause absolute chaos, as your words have put it, Chloe. I think a day one right is very unlikely, I think, for unfair dismissal claims. I think we are going to see that subjective probationary periods holding a lot more weight. And as I say, whether that probationary period is going to last for a year or not and be reasonable to is, something that is yet to be seen. But I think we are going to see a lot more weight put on those probationary periods. I think there may be a compromise found. I know in other jurisdictions, unfair dismissal claims can be pursued after 1 year rather than 2, which I think could potentially be a middle ground. I'm not in government, so no one's going to listen to me and what I think. But I think a compromise would be sensible, personally. Right. Any more questions? I will just allow people to pop any more questions they do have in the box. And then we've just got, as I say, our sexual harassment training. So we've got lots and lots of different sexual harassment training lined up, whether that's aimed at line managers and kind of SLTs or employees of all levels. Lots of different dates, all online. So you don't have to be local or trek out anywhere. But if anybody is interested in any of the sexual harassment training in line with the changes that do look like they are still going to happen in October, please do let us know. As I say, the law is due to change in October, and therefore employers already need to have taken those reasonable steps to ensure that they're not in breach of that obligation. So if you have any further questions or want any more information, as I say, you can drop me a message. You can get in touch with my colleagues who should still be getting in touch with you in relation to feedback forms anyway. And for any of our clients or not clients, we are also celebrating our 10-year anniversary in September and having our Biarni Bollywood Ball. Any of you who are on here, and I know there's lots of our clients that are, you know that we like a good party, a good do. And so you're all invited if anybody would like to come to our Bollywood Ball. That is happening in Sheffield on the 21st of September. So again, if you want any more information, do let me know. This is just about our training courses. As I say, I won't go through all these with you, but if you do want to request the slides, all this information is on here for you. And as I say, feedback forms will be sent after the webinar, so you can request a copy of the slides on the feedback form. If there's anything else you want to see from us, if there's any changes you see happening that you want more information on, that you think, oh, I really need to know more about that, just let us know, drop us a message, and we are really, really receptive to other people's thoughts and ideas about what they want to see, what they want to learn, what more they want to know. I literally, we decided, I think it was Wednesday or Thursday last week, oh, let's do a webinar on Tuesday. That'd be great. Everybody wants to know about this. So, we're really, really receptive to anything like that, and specific training as well. If you think it's something that would benefit you, do let us know. But thank you very, very much for attending today and for your questions. That was great. And for bearing with through the ifs, buts and maybes of what a manifesto may or may not bring. So thank you very much, guys. If that is our QR code, if anybody wants to sign up to our newsletter, as I say, or you can request it in your feedback form. And that's just our contact details if anybody does want to get in touch with us. So have a lovely day. We have finished a little bit early, so you can go and get some lunch. So thank you very much.